Hi, everyone. This is Mindy Staines with All City Real Estate, and I am here with Jeremy Brewer today. He is the San Antonio Board of Realtors legal counsel, and we're delighted to have him here today to ask questions, some of the hard questions. So if you do ask questions, make it very general, not specific to, I have a client that. So we're going to start. And first, Jeremy, can you just tell us about how you got into the real estate sector in law?
Sure. So I've been practicing law since 2010. I graduated from the University of Oklahoma. I came to Texas, and the first job that I got was at a general practice firm, and it handled real estate, handled litigation, family law, criminal law, and estate planning. And I didn't want to do criminal law, and I did not want to do family law. So I did real estate and civil litigation and estate planning. And that's kind of how I ended up there. And I practiced there for about 4 years. And then I moved down to San Antonio, moved downtown, and worked at a firm in downtown San Antonio doing the same kind of thing, real estate litigation. And I represented a variety of different brokers, agents, developers in a variety of different transactions, either from papering their transactions or in litigation. And after, I was there for about 5 years, and then I came over to the San Antonio Board of Realtors. And so I've been here for a couple of years, practicing and being the general counsel here at San Antonio.
Thank you. Well, what we're going to do today, we at All City, we have a hotline. And so we get a lot of interesting questions. And usually it's experienced agents that are just trying to make sure they're on the right track. But we do get some really interesting ones. So I'm going to give you just some of the general ones that we get just to make sure that we are also telling our agents the correct thing. So we had one as far as changing status in MLS. If you have an executed contract, but you have not received the earnest and option money yet, is it okay to leave it as active in MLS until such funds have been receipted?
That's a great question, Minnie. And before I get going, I should make sure that I give you all the legal disclaimer. This is not legal advice. This doesn't constitute legal. None of this conversation constitutes legal advice. I don't represent you or your clients in any of these particular matters. But regarding your question about changing the status, I get a lot of calls, people who are confused about the idea that they think that they don't have an executed contract until they have the earnest money or option money, which couldn't be further from the truth. An executed contract exists when both parties to the contract have signed and agreed to the terms of the contract. What people get a lot of times confused is there's deadlines associated with delivery of the earnest money and option money. And those deadlines, they think are what's called condition precedent to the contract formation, which is essentially a fancy way to say that there are some things that, people think that there are some things that have to happen before the contract's actually a contract. That's not true. So with regard to earnest money and option money, those are actually obligations in the contract. And if a party fails to fulfill those obligations, then they could be in breach of contract, depending on the facts or circumstances, which would provide the non-breaching party with whatever remedies either the contract allows for or whatever remedies are available to them at law. So with all that being said, if you have an executed contract, you need to change the status, because it's no longer, you have an executed contract. So you just have to change that status in order to reflect the accuracy of what the situation is on the ground.
All right. Thank you. And I know that's just been a big question, and we see probably practice in the opposite direction where, agents that are listing the property are afraid to change the status, because if they don't turn in the earnest and option, then it's back on the market. And then they feel that the home now has a black eye. Why was it back on the market? So, I think also from our standpoint is we just need to also tell those agents, hey, you know what, in agent remarks, you can always say, never made it to inspection, buyer never turned in earnest or option. And that way the house doesn't have such a black eye. Cause I know that we always do that, right? We're trying to represent our seller in the house in the best interest we can. And so sometimes we're like, okay, well, they didn't turn it in. Let's just not change the status. So thank you for clearing that up. All right. The next question, what is the most common grievance you see against agents, and what can we do to avoid that type of issue?
It's a great question. So Typically, the most common types of grievances in the state deal with TREC's other category, which usually comes into claims like false promises, where agents may, they said, I'm going to do this and they didn't do that, or where there's negligence committed, and where somebody knew or should have known that something was going to happen, and they didn't take any steps to prepare or prevent that. Fraud is also in the other. I think some of the other things are failing to report history. So a lot of times, if something happens and you fail to report like a felony or criminal activities or whatever, update with TREC, that's another very common grievance that's filed. Property management issues continue to be among the top grievances filed, and typically those deal with sometimes with negligence, sometimes with fraud, sometimes with false promises, but a lot of times they deal with commingling. People who engage in property management, sometimes they think that they put all the money together, and you can't do that. Your client's money has to be separated from your money. You can't. What I often used to see was a property manager that would own properties, and they'd manage their own properties, and they kind of throw the money from their rentals in with the money from their clients as well, all in one gigantic account, and commingle the account. And you can't do that. You got to keep that money separated, even though maybe you're handling your own property management. It's still got to be separated out from your client's money. So those are probably three of the biggest. I mean, other kind of incorporates a variety of different things, but those are probably three of the biggest complaints that TREC continues to see.
That would probably explain why we saw, I know that we just had a lot of forms updated, and it seemed like the property management forms were the ones that really got the most of the updating. And at All City, we always tell our agents, do not practice property management. So as a matter of fact, I got a hotline question the other day, and I even told them, even helping them with the lease is a little bit, to me, practicing property management, because they have to, the seller or the landlord has to live with that lease, and so does the tenant. And so what I've started recommending is, since we don't practice property management, we just help them find the tenant. And I tell my clients, you can use Law Depot, a couple of different ones that will help walk them through the contract, and they're very user friendly. And then that puts us at arm's length from even the lease, because
Yeah, you could definitely have a policy. I mean, technically your real estate license, and if you're a broker, you're allowed, and you can practice property management under the guise of your real estate license. I always tell clients when my clients, I represented brokers that did property management, I always tell them that they were doing the Lord's work, because the revenue on it, I always thought, one phone call to me could erase your entire month's revenue.
yes. And I mean, really, if I was just helping them find the tenant, I'm like, I would rather the landlord and the tenant take care of any issues that happen through the length of that lease than me, because usually there's nothing that I can do about, the property itself, or something that may come up. So okay, the next one, at All City Real Estate. Well, actually, this is another policy that we have. We don't allow agents to provide dual agency and require that intermediary status must be with appointments. Can you expand on why that is a good practice and how it helps protect consumers and agents alike?
Sure. So the intermediary status is essentially when the broker is going to represent or going to have some engagement with both sides of the transaction, and in that situation, it kind of renders the broker's ability to provide counsel and advice, or to interact with their clients in a way to help them throughout the process. They have to be fair to both parties. It limits some of the things that they can do. With an appointment, it allows the broker still has to remain in that same position. The broker, because they're the intermediary, but their appointments can actually represent the client, on either side, whatever the transaction, and provide counsel, opinion, advice, and that kind of thing to represent that client in a way that provides the client with representation. As we know, purchasing a home is probably the most important or the biggest decision that people will make in their lives. And maybe they make it more than once, but it's, they're rarely going to find a situation where they're paying more or spending more money than they do on a home. And so representation is super important in that situation. I think it's important to have a client have representation. And so, I mean, while there is some circumstances where some, brokers or where they're allowed, they can act as an intermediary to get, either, on both sides of the deal or whatnot. It does change the ability of their ability to represent the client in the transaction. So having appointments really does provide the clients with a higher level of experience or higher level of representation than you would get in a traditional, just a basic intermediary status.
Yeah, and I use that as an opportunity when I explain that to clients, to say, we're talking about the value that we're adding to them. We don't want to take anything away, right? If we step into that position and we can't represent them, then they're really not getting the full benefit of the services that we offer. So I always explain it to that too. And I think that they are like, oh, we're glad that you do that, instead of, some agents saying, well, I want both sides because I want commission from both sides. So it's we just like to have that as a best practice for sure. Temporary leases, we saw that become really popular during multiple offer situations when homes were selling so fast, leaving sellers homeless for a period of time between selling and buying. When must a seller tenant vacate the property when they are occupying a home after closing under a seller's temporary residential lease?
So that's a great question. And the answer is typical lawyer. It depends. When it's the temporary lease can be negotiated, and you can have like a certain time frame as far as where a seller can remain in the property, however long the buyer and the seller negotiated. When they have to vacate is typically either under the expiration of the lease or if they're in default under the lease. One of the things that I get a lot is, in a seller situation, when you're selling your house and you become a tenant of that same house, it changes the nature of obligations. And so I've heard people call and say, my sellers don't want to deliver the keys to the new buyer because it's their house. And I have to remind them, well, if you've sold the house, it's no longer their house. Like, they have a right to possess the house, which under a lease, they have a right to quiet enjoyment, have a right to utilize the house for the purposes specifically stated in the lease. But they have to turn over the keys. They have to give the new, because the buyer is now the owner of that property, and the buyer has a right to go into the property or check or to do things, as long as it doesn't violate the quiet enjoyment and it complies with the terms of the lease. But as far as vacation of the property, you got to leave when they have to leave, when the lease says they got to leave. And if they don't leave, then they become a holdover tenant, and then the buyer gets the pleasure of either seeking judicial matters to get them removed from the property, which basically means they'll have to go and evict them.
And also just a question that we get too, which is not stated on the lease that we fill out. I'm always thinking that those are so short, those documents for a lease. Are they, I've gotten the question, is it 5 o'clock or is it midnight that they need to? So if they're supposed to, if their lease ends on the 25th, do they need to vacate by midnight or by 5 p.m.?
I mean, so if someone came to me and asked me that question, regardless of whatever the idea is, I'd just say it's midnight. I mean, I think that there's a lot of hay that could be made in that circumstance, but ultimately, my opinion was always, it's just not worth the hassle. If someone gets out by midnight and they didn't get out by 5 p.m., I mean, as far as, the damages associated with that, I think it would be really hard for a landlord to say, hey, I was significantly damaged enough, and that damage is worth what it's going to cost me to deal with that suit. So, I mean, if they don't vacate by 11:59, the day of the end of the lease, then, the landlord can go forward and move forward with their judicial remedies under an eviction. But I wouldn't, even if it said 5 p.m. and someone came to me, I'd say, it's not really. I mean, you're going to go spend, $300-400 to evict them, plus they're going to be $100 or $300-400 of court fees, plus another $100 in service. And at the end of the day, if they got out like at 8 o'clock, the judge is likely going to look and be like, hey, what was your damage between that 2-hour period of time? I mean, it's going to be really hard for, you to quantify that, I think.
And I always say, don't leave your clients with assumptions, right? So I always say, help them arrange that, so Okay, so at 5 o'clock or maybe at 4 o'clock, they're going to do a walkthrough. And then that way at 5 o'clock, as long as it's communication, solves a lot of problems. Otherwise, one party's assuming 5 p.m., one party's assuming 11:59, and then there creates the problem in between those
Yeah.
6 hours. So definitely not worth it. But it is a question we get quite often. So thank you for that. Can the parties also, speaking of a temporary residential lease, can the parties agree to charge $0 as the rental amount when they are using either the seller or buyer's temporary residential lease?
Yeah, they actually can. So typically I think the question for that question probably comes up because people wonder if there's consideration for the lease, and it's pretty clear that the consideration found in the purchase and sale and the obligations associated with the purchase create consideration for that lease. So yeah, if the parties negotiate and they negotiate, $0, they can do that.
All right. Thanks. Yeah, we saw that a lot. And again, I think educating when we were in the multiple offer, I think sometimes we just got leases in place and didn't really, I saw a lot of people not really explain that to their clients. And sometimes we did have holdover tenants. And so it's like usually if we see the zero for the rental amount, the holdover usually has something. And when people were waiting for homes to be built, we saw that creep in there a lot. Some of them were like, "Oh, we're shocked." Well, did anybody tell you what, the holdover amount meant? So,
Well, I think it's what the amount of money you charge has absolutely nothing to do with the time frame on the lease. So if you charge $0 for a month for the lease and the lease ends in 90 days or ends in 3 months, that's typically the temporary lease is usually about 3-month window. But if it ends, just because there was no rent, or the amount of the rent was $0, doesn't mean the buyer or the seller at that point, or the tenant, I should say, the tenant still has to vacate the property, whatever that time frame is. They got to vacate it. And if they're a holdover tenant, then the eviction is usually premised on the fact that they're occupying the property beyond the term of the lease, which is I would have said 5 years ago, that's probably an easy open and shut kind of case. Over the last 5 years, things have kind of moved all over the place. So I don't know if it's as easy an open shut case, but I mean, if someone is there beyond the term of the lease, then I mean, it's pretty clear, at least in my opinion, that they're there beyond the time frame that they've been allowed to be there.
True. Very true. That was a challenge. I'm glad to see that we're in a different market. We're not dealing with that as much. So hopefully that continues to get better. Question: if a seller incurs a theft or vandalism on their property during the listing and they file a claim on their homeowner's insurance to remedy the damage, must they update the seller's disclosure to identify the claim? And what if the remedy, and if they didn't file a claim, do they still need to update the seller's disclosure on that?
So this is an interesting question. There's a couple different ways to look at it. Technically, my advice when anybody calls is I always tell people no one ever sued somebody because they disclose too much. If your client is adverse to being sued, then like I said, no one's ever been sued because they disclose too much. However, I guess the caveat to that is I guess it depends when that disclosure is made. But if you're using the TREC standard disclosures, the things that you really have to disclose are damage related to flood. That was recently updated in the past, I think, year or two. We had to update a lot of things with regard to flood or damages associated from flood. If you're using the Texas Realtors disclosures, there is a line, I think it's in paragraph 7, where it talks about you have to identify if there's ever been an insurance claim on the property or if you ever received money from damages associated with the property. So in that situation, I guess it kind of depends on the nature of the claim. So if somebody came in and stole a picture off the wall and they didn't damage the property, they just gently opened the door and they walked in and it didn't have anything to do with the property, I don't know that there would be an obligation to disclose that theft. However, if somebody came in and stole the air conditioning unit to the property, or some like the copper associated with, or something, I think that there would be an obligation to disclose that. And if you're using the Texas Realtors seller's disclosure, if there was damage associated from that activity in the insurance claim that you filed, you'd have to disclose that as well so you'd have to update your sellers would have to update the disclosures under that situation.
And, it's interesting because those two forms, when you talk about the Texas Realtors disclosure and TREC, I mean, what is your advice on that? Is there one that we can't really, there's nothing wrong with using either form, but what is some of your advice on that?
I mean, I think the Texas Realtors forms, I mean, obviously Trek promulgates certain forms, and Texas Realtors has expanded forms beyond those that Trek promulgates. And so utilization of Texas Realtors forms is limited to those people that are realtors, and that technically if you're not a realtor, then you a Texas Realtor member, you shouldn't. It says on the form, utilization of this form is for Texas Realtors members only. That doesn't necessarily stop people from using the form. And it doesn't stop people from pushing the forms on the internet so that somebody could just download them and use them. I don't know anybody or any transaction that would fail because somebody used a form that they weren't authorized to use. I don't know a court that would say, well, you weren't allowed to use this form, so the deal fails. I don't know that would be the case because of the form that was used. I guess his preference Trek is more closely aligned to the statutory requirements. That if you went to the property code, it kind of outlines in Chapter 5 of the property code what the disclosures are and what things have to be disclosed. And that's a lot of what Trex is. Texas Realtors forms are maybe a little bit more than that, and a little bit beyond those things. Hence the any damage disclosure versus the just the flood damage disclosure. So I guess it's kind of up to whatever you want to use. I mean, I don't know that the deal is better because it used one versus the other.
Right.
I think if you didn't disclose the damage associated with a property and somebody found out about it, or the insurance claim and somebody found out about it after, that could cause you some risk. Somebody may say, hey, you should have told me, but you didn't tell me. And so maybe in that sense, that line item in the Texas Realtors form maybe makes it, a little bit more attractive. But either way, I think they both meet the state standard required statutory requirements for disclosure.
Yeah, and I always guide people. I'm like, again, like you said, it's always better to disclose more. And, when we are helping buyers, it's really beneficial to know if there has been an insurance claim, because sometimes it can affect, the qualification when the lender says, okay, here's what your insurance is going to cost you. There's been several claims on that home, and now your debt to income ratio is too high. I've actually had a deal cancel for that. So it is good because that way it's not kind of a shocker when the buyer is getting their shopping for their insurance. So a little bit different perspective there because it's coming into play just from the insurance. But I know when I represent buyers, I like to see that one so that we can see and anticipate any problems moving forward. So thank you for that. Can you expand more on Trex guidelines that state real estate license holder cannot perform an appraisal or provide an opinion of value for real property unless they are licensed appraisers?
So yeah, this is an interesting thing. I think a lot of people, they get this idea that when they do their CMA, is that an appraisal? And it's not. And an appraisal, as a realtor, or as a real estate agent, you can't represent to a buyer or to a seller that this is what the value of the property is. You can represent to them, hey, this is what the market may be for this product, or this may be the price that it could sell for. But you're not allowed to say, you're not allowed to use the term appraised or use, appraisal or anything unless you are a licensed appraiser. But your CMAs and your other things like that, as long as it's clear that these are analysis of what the market is bearing and what's going on in the market, utilizing your comps, you should be okay. There are disclosures that you can find on Trek's website if you're doing that when you're doing your CMA. If you're saying, hey, just that this is not, and they say things to the effect of, this is not an appraisal, or this is not an opinion of value. It's an opinion of what it could sell for, essentially, which is, I know it sounds like a play on words, but it's a big deal when you're doing it, that you get the words right. Because words, as one of my law professors from my first day of law school, I think he told me that somebody made a comment and he said they use these weird words, and they said, it doesn't really matter, that's what I meant. And the professor was like, well, words matter, Beavis, words matter. So they definitely do matter.
Yeah, I think that's really hard because sometimes we tell our clients, well, we're providing this to, again, anticipate or see what what an appraiser would do, when because we try to align it right with the last 6 months, 2 mile radius. So yeah, I think the words are important in how we convey that to our clients. Now here's a little twist. So sometimes we have people in our industry that, yes, they're a realtor, but they're also a lender or they're also an appraiser. So what about an appraiser that's also a realtor? Or
So under the statute, an appraiser could render an opinion for value. And as long as you're using appraising principles, I think it may be, if somebody was a licensed appraiser and they were a realtor and they went to a client and said, this is your home, this is the appraised value of your home, without actually doing an appraisal, I think it may be complicated and maybe put them in a little bit of a sticky situation. But I mean, they can say that because they are licensed appraisers, but the premise and why they can say that is because they are doing the appraisal. So if you come in and someone said, hey, this is an appraisal of your home, they may be allowed to use the words, but there's a lot behind the words there. And if something comes out wrong, they might find themselves on the negative or the wrong side of the lawsuit or a lawsuit.
and I know that came up a lot because we talk to our clients a lot when we have home values that have skyrocketed and they're concerned about their taxes, and we try to offer help. And sometimes I think that puts us in a predicament even with our data, right? So is there anything you can expand on that when realtors say, well, I help my clients fight their tax appraisals? Because you are sharing sold data in a non-disclosure state. So
yeah, so I think the thing when it comes to non-disclosure, I think what people often get confused, and they think that a non-disclosure state is a state where disclosure is prohibited, and that's not the case. So in a non-disclosure state, in like Texas, what that means is that the state can't penalize somebody for failing to disclose or not disclosing that information. But that doesn't mean that a party can't be compelled to disclose, or a party cannot disclose if they choose to. I mean, I see it all the time in situations where, in divorces, where appraisals and where values and sold price and things like that can be compelled through discovery to be disclosed. And, there are legal ramifications for failure to disclose that could lead somebody or land somebody, up to, some penalty, some financial penalty, or up to in prison. The thing when it comes to, and a party could disclose if they wanted to tell people, and they wanted to provide the information to the city or to the county or to the state or to whomever, they could do that as well. There's no prohibition on them doing that either. I think what it really comes up to is in a situation where, like, we have conversations with the county appraiser all the time. And he tells us repeatedly that he's 98% confident on his valuations in residential market space because he gets a lot of data, not from the MLS, not from San Antonio Board of Realtors, but from people who take data to him. Like when they go protest their taxes, they'll say, hey, here's the value, all the values and everything they got. And they grab that information and they take it and they put it in the database. And, and they ask you if you can leave it with them. You don't have to leave the evidence with them. You can tell them, I'm not going to leave the evidence with you. I'm just going to use it to justify my claim that the appraised value is incorrect. But he tells us he gets most of his information from people coming in and protesting their taxes. I mean, which I think the biggest thing to that is if somebody doesn't want to, if the industry doesn't want that to happen, I think that, the biggest thing is to educate your client that they don't have to leave that. They don't have to give the information to the appraisal or appraiser district if they don't want to. I mean, they can, but I mean, it's theirs to do what they want with it.
Yeah, I think that changed a lot. I know when I fought mine a couple of times, just going in, and it was very easy, right? And I did have the evidence, and I took it with me. And now, after once with COVID, it was like do it all online, right? And so we are giving them a lot of data, but you also give them that data so that you can try to avoid paying high taxes.
Yeah, it's kind of a catch-22. Is the evidence to support your case? I guess the question is you can always check the box, or you can always say, look, I don't want you to keep this, and then they won't keep it. I mean, but I don't know that is a box that everybody checks, or that's something that everybody does.
Right. Probably not paying too much attention to that at that point. Just trying to lower your taxes. Um, okay, let me move on to this section here before we start taking some questions and answers. Um, one thing I hear often from members and leaders of the real estate industry in our area is the concern regarding professionalism in our industry. With real estate being the largest trade industry, how do you feel we can improve professionalism amongst agents and keep the realtor brand relevant?
That's an interesting question. I hear all the time, and almost every survey that we send out, that's professionalism is usually the number one thing that people complain about or say that they deal with. There's two things I think. One is a little bit tongue in cheek, but one is is not. So education is probably the biggest factor in in enhancing the professionalism of the industry. I think a lot of times people come in and they get their license and they just start running, and then they do their mandatory CE, but they don't, they don't do anything beyond that, or maybe they don't pay attention to the CE. I know, and this happens in almost, I think, any industry where you have continuing education requirements. Lawyers do it too. I can't tell you how many times I sat in my office with, and the partner or somebody was just, they're doing their CLE, but they just have it on the background on their computer. They're doing a video, and then they're just kind of like working and doing other things and waiting to hear, waiting to hear keywords. I think engagement in that CE. So maybe going to live CE, doing things live, creates and fosters that engagement. Getting involved in the industry as a whole, getting involved at the state and national level, getting involved at the local level, I think is another thing that increases professionalism, because you get exposed to other people who are also dealing with the same kind of thing, and people who are trying to engage and better themselves. I think the last thing I would say is probably, and this is a little bit tongue in cheek, is read. There's a lot of information that gets sent out. And I know realtors, people say that realtors don't read. And, they say it enough that it has become something that is, that realtors even say about themselves. But I think reading, there's a lot of information that's put out there for you to get, that isn't a formal class. It's education, right? It's like there's education and there's information that came out about, changes in the law or changes in forms or changes, and they get sent out in weekly, monthly, and newsletters and magazines and things like that. And I think sometimes people get caught up in every industry. They run so fast, they don't take time to, change their shoes, or they Stephen Covey used to say, he used to say, sharpen your saw. You're cutting a tree. He used to say, you're cutting a tree, and you could, as your axe gets dull, you just start chopping harder. But if you took time to stop and sharpen your axe, you'd actually get more productivity with less effort. And so I think, if you take classes, engage, and read, I think those things would enhance professionalism across the board.
And I know SABOR has been really focusing on that, and the Realtor Academy has been changing a lot over the last few years, and it's very competitive, and it has a lot of classes, just because SABOR is doing the surveys and we know where we're seeing some weaknesses, and that's the answer. It is education. Thinking of that, being a market manager for All City Brokerage, how can we, and I've thought about this, so our agents are independent contractors. How can a brokerage almost require that, not just their CEs, but require that there are classes and education attendance, and that's the thing, is getting people engaged, attend, so that if they're not reading, we're giving them the information. Because as brokers, there is a responsibility, right, to prove that you're giving that education to your agents. But it almost seems like there needs to be a way to get it back to where the agents are showing proof, like, yes, I did this, I did take that. So I feel like that's a struggle that I see with brokerages. And what would you be able to say about that, since they're all independent contractors?
I mean, a brokerage, just because you're the source of the people that work at the brokerage or independent contractors doesn't mean the brokerage can't have a policy manual, can't have some requirements associated with participation at the brokerage. And while in a brokerage as a group as a whole, Trek sets the standard licensing requirements, and so there's very little that anybody can do to say, hey, look, in order to keep your license, you have to do more than what your state requires. And I know people say that all the time. They get like, hey, we should, force this or require this. And unfortunately, the state is the entity that gives the license. They're the ones that maintain the requirements for keeping your license. And other people outside of that have very limited options when it comes to, real, I guess, requirements. But a brokerage can say, hey, look, you know what, you're here, you're here as an independent contractor, but there are certain things that I require. I would imagine it's very similar to like, desk fees. It's not the same. Every brokerage has a different model, and they all operate independently and do things differently, but they all have different policies and different policy models as well. So I think if a brokerage said, hey, I want to have this be, you want to be here, this is the requirements to be here, and I'm going to give you all these things, then I guess they could do that. I don't know that there'd be a huge impediment. If all the brokerage collectively started to do that, then I think then you start to run into a problem, because then you're starting to get antitrust claims where, right, the groups can't collectively as a whole make decisions, but independently they can do whatever, they can make whatever decisions they're trying to make.
No, I think that would be helpful because, it's just with, 15,000 agents, we want to make sure that we're putting the right agents, as we say, the right agent matters at All City. Then we want to make sure that we're putting agents in front of our clients that have been educated and stay educated, as things change all the time in real estate. Regarding residential service contracts, we saw those not being included during the high multiple offer situation, but now seeing the new walkthrough form that was just updated in July, it has me curious. If the buyer purchases their own, is the seller in fact responsible for reimbursing them if it is not included in the contract? And the reason why I asked you that is because I really went, after I saw the new form, I referred back to the 1-to-4 family contract, and it says that I believe it says the seller, if the buyer purchases their own residential service contract, the seller shall reimburse the buyer at closing. But you have to put a dollar amount in that section. So if you don't, and they do purchase it, what happens?
Honestly, I think this kind of lends itself back to that professionalism conversation. It's a negotiated term. And I think what I hear from members, and one of the things when the Realtor Development Committee talks and does things about their weekly tips and the professionalism conversations, is that it's not necessarily, I don't know that it's professional to leave blanks in your contract. If you're going to, if there's a blank there, then, it's there for a reason. So one of the things that one of the tips that Realtor Development Committee puts out is don't leave any blanks. And so if you have a situation like that, it's a negotiated term. If the idea is that the seller is not going to pay for it, then, that's negotiable. That's negotiate. If the idea is the seller is, then that's negotiable as well. But in the amount is also negotiable. But the walkthrough, you're acknowledging, essentially saying that the buyer either has or hasn't. And I think if you have the 1-to-4 filled out, and the 1-to-4 says the seller is going to pay for it, then the seller that's a term in the contract. If the seller is not going to pay for it, then that's a term in the contract. So there's an absent that obligation, or absent that negotiation, the buyer can buy theirs, and the seller, if it's not there, then I don't know how the seller could be compelled to pay for it in a situation when they didn't agree to it as part of the terms of their
agreement. And I always wonder about the word shall. We were looking it up when,
Yeah. So, again, in that provision, if the parties have agreed to it, then the seller has to. But if the parties said, hey, if the buyer says, I don't want you to do it all by my own, I'll take care of it, then, there isn't, that's a negotiable term. So.
Yeah, I know. I did like seeing that in the walkthrough, because sometimes agents, when we're writing these market trends, and we're saying, okay, it's multiple offer, we're not putting in a residential service contract. I was telling a lot of the agents that we have, make sure that you educate your client on what a residential service contract is. And, if they want to purchase that or the realtor purchases it, that they educate them on it. Don't leave it out of the conversation. If it was out of the contract because it's multiple offer, don't leave it out of the conversation, because then later after they're closing and they're saying, hey, what's a residential service contract? And it was something that was in the 1 to 4 family they signed. You didn't go over it with them, and maybe they didn't read it, right? They were just signing. Then, I think that we may see some of that come up as those buyers are going to be, getting into their year-long in their home for a year, and things break and they're like, hey, I don't have anything in place. What about this? Did my agent ever tell me that? So that's just definitely a really good practice. And I liked seeing that on the walkthrough form. So
Yeah, and don't forget, if you have a relationship with the company, you have to, as the agent, you have to disclose that as well. I mean, you have to provide disclosure that, if there's any kickbacks, or if there's any payments, or if there's any, any relationship contextually, you have to disclose that as the agent to all the parties.
correct. And it really is more about compensation. I mean, I know that we develop rapport with certain reps. Um, Maybe they come to, support our brokerages and things like that just by their presence and their education. Does that institute a disclosure of relationship?
I mean, I come back to, I don't think that anybody has ever been sued because they disclosed too much prior to the sale. I think that it's a good best practice to disclose. I think also, I mean, if a client says, hey, I want to buy one of these, or I want to get one, it may be in the agent's best interest to say, hey, these are a couple people that I know, or, here's a list, so it's not just, hey, this is my guy, or this is my gal right here, because I think at that point, then you start to reduce the distance between you and the transaction. You always want to keep yourself at an arm's length from the transaction, especially when it comes to those kinds of things.
That's a good point. I like to give three inspectors, 3 home warranty companies. I was in design before, and we had issues where if you did recommend certain contractors, it was like you were the one hiring them instead of the clients. And that could definitely get you into a lot of trouble. So coming from that industry over here, I am really good about, making sure that I am not the one hiring or selecting those individuals.
I was gonna say that goes for just about anything. I would, if someone called me, I'd say, don't be the person that hires any of these people. I have people that call and say, oh yeah, I talked to an attorney for my client, and I always tell them, like, that's a terrible idea. Don't do that. Don't hire an attorney. Don't talk to an attorney. Don't get information from an attorney. All you're doing is essentially you're inserting yourself so close into a transactional situation that if there is something that goes wrong, I mean, you're the person, you're the source of the information. We used to say, realtor development used to have a phrase like, don't be the source. I think Pat Strong was the one that told it to us. But don't be the source of the information, be the source of the source. And, that's in a way to keep yourself, even further, insulated, so that if someone does something or says something that doesn't go right, I mean, you don't want to be so close to the transaction that it's obvious that you should be included in the lawsuit.
Right.
Your broker will be not happy about that.
All right. And we did have some people email some questions. So I'm going to start with one of those. Let me get on to hers. Okay. One agent wanted to know what our options are to be effective with a dispute that isn't worth suing over. So I'm assuming it's probably, when we have clients that are like almost saying, well, I'm going to sue them or things like that. I mean, this is where we all cringe as realtors, and we know that, it's not our lane. And so it's kind of like, what do we do as a good next step, good best practice when clients start telling us those things?
So I think there's a couple different things I think that could be done. Technically, the agreement, or depending on what contract you're using, it probably has a mediation clause in there where it says the parties will mediate in good faith, which is usually a defensive mechanism, or there's an arbitration, which again is also, a defensive mechanism, meaning that a party seeking to institute a lawsuit doesn't have to do either one of those things. It's the party defending that usually says, hey, wait a second, before you get to point B, you got to go to point A first. And so some of the things that are available, the Bexar County has a alternative dispute resolution center that it operates that, it is basically a mediation. There's trained mediators. They may not be lawyers. They may be lawyers. But they're trained in how to get parties, to resolve their or alternative dispute resolution or to something. There's other options. I mean, I think once you get beyond those things, if your client's telling you, hey, I want to sue, I think you can throw some of those things out. But I mean, whether or not something is worth suing over isn't really a decision that, I would advise a realtor to get involved with. I wouldn't. I mean, it's not, if you tell your client this isn't worth suing over, and then it turns out that something doesn't go their way, guess what? You have now become a defendant in some lawsuit, or there's a higher probability that you will be. So, but I mean, people who call me and they're like, hey, what can you do? What can we do? I always tell them, well, if your client wants to, they can go to this mediation center down in Bexar County. But for the most part, if they get to that point, I just tell them you probably need to have your client just talk to an attorney to tell them what their rights are under the agreement. I would also discourage any realtor for being like, hey, here are your rights under the agreement. Here's your remedies. These are the things you can do, or, providing interpretation of the client's legal rights under the contract. I know agents really get themselves in the situation where they're like, oh, I feel like I have to show my value. That's what I'm there for. You're not really there for that. Your job is to facilitate the transaction. If somebody is going to have a dispute under the agreement, you don't want to be in the middle of that. There's a strong likelihood that you will be at some point in time, because almost all real estate litigation has one thing in common, and that's the plaintiff knows somebody's at fault and they know it's not them. So they say, everybody else, we're going to throw everybody else into this and see what sticks. But the things you want to do is just kind of steer clear from giving legal advice, from rendering an opinion, trying to render an opinion. I think the easiest thing to do is just to say, hey, if it's not going your way, seller, or not going your way, buyer, I mean, you should talk to an attorney, because I can't practice law. And you can always fall back on I'm not allowed to understate law. I'm not allowed to practice law as a realtor.
I do, just on that note, I've had some clients that came from New York. We have someone else that's talking about Chicago, and it seems like there's some states where there's really a separation, where the realtor is really just there more for showing it, and they don't write the contract, an attorney does all of that. So I don't know. I mean, it's interesting. I don't think that will ever change in the state of Texas, but sometimes it does. It puts us in this weird position. So I'm glad you said that, because sometimes I was wondering, like, do you go back and refer to that mediation part on the contract? And I don't think I would be 100% comfortable. So I'm glad you told me that. She kind of just got me, like, where I can say, just call your attorney or whatever attorney you need, and definitely not refer the attorneys. I'm always getting that. Do you have a good real estate attorney? And again, I don't want to just give.
Yeah, I think if you get into the mix of referring somebody specific, and that person turns out to be wrong, or turns out to do something wrong, I know the plaintiff doesn't care. The one thing, like I said, they have in common is it's somebody's fault, and I know it's not mine. So it's just never going to be a situation that you want to kind of be, sticking yourself in.
Right. Okay. Do we have any questions? Okay, I see one up there. And this might have been in relation to one of the other questions. Yeah, in relation to the first question, I think Taylor is asking, if they don't pay option, though they don't have active option, so should we move it to pending then until they turn in option? And that is something to his question. In our MLS here in SABOR, we have active option status. I also have Austin MLS, Central Texas MLS, and they don't use that term active option. So I think that's really why I get that question a lot here, is because it's a status that says active option. So if they're not paying for an option, if they haven't paid the option money, are we supposed to change it to pending versus active option? Is kind of his question.
Yeah. So, I mean, This is, if I recall correctly, so your active options, essentially you have an fully executed contract, but it's within an option period. And then there's active contingent. I think there's a active with contingencies, which is essentially you have fully executed contract, but there's contingencies. And then you have pending, which I think is you're under contract. There are no options and there are no contingencies.
Right.
I think in a situation where you have no option, I mean, the next thing is pending, unless there's contingencies to it, which and a lot of times there probably won't be, but it may be, the contingencies like I'm under here's my contract, but it's contingent upon me selling my house before I can close on or there's this. So I think that you would go to pending in a situation where there are no contingencies and there are no options.
Right. And I think, let me just clarify too. I think what Taylor's thinking is, and I think I know the answer based on what you told us earlier. So if they did write an option period into the contracts, they said, we're going to pay $100 for a 10-day option period, but they have not paid for that option period yet, we're still, because it was in the contract, we're still supposed to change that status to active option.
If you started out and you say, if you change the status when you get the executed contract and there isn't and there is an option, then you'd be in your active option. If they failed to pay, then they have no option, and so then active option would be the incorrect status because there is no option. Essentially, failure to pay the option just means that they don't have the ability to back out or for whatever in that option period of time, and so there's if they do fail to complete the contract, there are remedies for that. They could be in breach of contract. If they're in breach of contract, then the contract calls out specific remedies that could be there, but there may also be other remedies available at law. I think it seems, I know people are like, in a fast moving situation, you may say somebody signs, on Friday and then on Monday, you're out. You have to update your statuses within the rules, timeframes of the MLS. And to hold out the idea that there is no, that it's not a valid or it's not under contract because they haven't paid the earnest money or paid the option is it's an incorrect assumption.
Right. Okay, I haven't. And if anyone didn't hear that, so Jeff was saying if they pay the earnest money and there is an option on the contract that title is taking a portion of that. So they'll take it out of the earnest money and then the earnest money they'll be short on the earnest money.
And I think in that situation, I think that the changes in the law allows the title company to use the same check, or they could put it all in the same check. I don't know that would, in that situation, I don't know that would create a circumstance where there's not a problem, because I mean, in any situation, you're kind of stuck. So theoretically, if your option is, $10 and your earnest money is $1,000, then your check, even you could do a single check, but it should be for $1,010.
Yeah, again, I think that's why communication is key. Somebody needs to see what the actual client, the buyer's intentions are and what they are paying for. Did you have another question? Okay. Let's see if we have any other ones. Oh, Taylor, can you unmute Taylor? Give us just a minute, Taylor. And we are recording, Taylor, so no dogs barking or babies crying in the background.
Can you hear me?
Yes.
Hello?
Go ahead, Taylor.
Okay. Hey, I just had a question about what happens if the contract is being wholesaled and it has a buyer's agent written on the original contract, but then let's say I'm representing the end buyer and I have the buyer's representation with it. Does my buyer's representation supersede the buyer's agent that shows up on the contract for the property for the commission?
That's probably a little bit more specific than I can get into. I can tell you that in a situation where a property is being wholesale, typically how that normally finds its way to light is somebody goes to a seller and says, hey, I want to, I will buy your house for X amount of dollars, and I will set the closing date at a month, 2 months down the line. Then in between that, and then typically what I've seen is in that situation, that buyer will say, hey, I also have the right to cancel at any time for any reason. And what they'll do is they'll use that time frame, the 2 or 3 months in between the execution of that agreement and the purported or scheduled closing date, to try and sell. They try to what they call a double close, but typically what they're essentially doing is they're trying to sell that ability to buy that contract, or the ability to buy the property through them. And as far as who would control, I think they're different. I mean, it'd be hard to say, and I don't know exactly how to answer without getting into the nitty gritty or specifics of it, which I can't do, but the first agent is, would probably, in a situation where, the first party is represented by an agent and they're, I guess it's a weird deal because wholesale, you're not really buying the property, you're buying the agreement. I mean, that's just kind of the shtick of it. I mean, in every situation I've seen a wholesale, it's the end result is the property. The goal is the property changes hands, but the transaction is more so about you're buying the right to purchase the property. You're not necessarily buying the property, and they try to work it out so that it closes on the same day, so it looks like it's a purchase essentially. So the second buyer is essentially buying the property, but it's a lot more. There's a lot more to it than that, and I would say that wholesaling is highly regulated by the legislature, and there are so many disclosures and so many things that you have to do if a property is being wholesaled. And failure to comply with those disclosures and failure to comply with those requirements could put people in a world of hurt, because it essentially can be assumed that it is an automatic violation of the Texas Deceptive Trade Practice Act, which can carry, up to 3 times treble damages, meaning basically your damages times 3 if times another 3 if you did it intentionally. And so there's a variety of issues that come up with wholesaling. That it's a very, very sophisticated situation. And if you have somebody that's engaging in wholesaling, I would suggest that they talk to their attorney to make sure that they meet all those requirements.
Thank you. All right. I think last question I wanted to ask you. So we talked about professionalism, and I think that's more of a something that's affecting our industry from within, right? From within the realtors. So in the real estate community, we talk amongst ourselves about the biggest challenges our industry faces, probably more from the standpoint of what is putting our industry at risk. So from your perspective as an attorney, what do you feel is the biggest concern facing the real estate industry?
That's an interesting question. I know she didn't give me any advance notice on that one.
No, I didn't. So on the fly.
I think, from my perspective, where I currently sit as the general counsel and the vice president of risk for SABOR, I think a lot of it is reading. I mean, it really is. I think I can't tell you how many times I would have people call me, and I'll give you an example. So when the ethics requirements changed and there was a requirement to take ethics, and that was about earlier in the year. I know the board sent out, it was like a 2-year window before the decision was done and before it was effective, and you had to actually pull the trigger on taking the ethics. And I can't tell you how many times, we sent out messages and sent out information informing people, letting them know in a variety of different means and a variety of different mechanisms. And I remember I sat in a meeting at one, I heard from people who were like, oh, I never saw that, or you never sent that information. And I can tell you how many times people, I could go back and look, I say, I can tell where the email goes. It went into your junk. And you know, and like how many times I got a lot of calls from people like, you never told me, I didn't know that I had to do this by this time. And I could go back and see, well, all of my emails went into your junk. It was just auto filtered. So I think the risk, to me, the biggest risk in the industry is, I mean, is just reading. It's paying attention to those things. I mean, this is a profession, and it takes it takes the effort to pay attention to those things. I know a lot of the complaints that we get is, oh, you send out too many messages, or always, and you know, you send out too much, and we get so many emails, and I mean, I know I get tons of emails. My entire career, I've gotten, you know, I get hundreds of emails every day. And you know, it's, you never know if there's one of those emails, you know, it has the kernel of information that you need in order to, you know, be either a defendant or not be a defendant in a lawsuit. And so I think reading is probably, to me, I think it's, you know, goes along with education professionals, but I think reading is a big deal. I think if people spent more time and looked at those things and paid more attention to it, they would find themselves in situations where they were much better prepared than they may otherwise be.
Yes, I do remember that. I mean, people were, they pay attention when their license does not get renewed, or it gets, you know, their livelihood of making an income is affected because they didn't take, you know, an ethics class. And really, I mean, we were one of the few states, I believe, that, you know, we had it within our legal for so long. And I thought that was a great change to add that, because if we're complaining about professionalism, or we get in a transaction with another realtor and we feel that they're being unethical, and, you know, we don't have this ethics class standing alone to show how important it is, then, you know, what could we expect? So I really appreciated that change. And I think what you're saying, I mean, you see it from, you know, SABOR, and even funneling down from the 15,000 to all the individual brokerages. We all face that too as leaders. That's why we're doing this today, trying to find all these different formats to get education in front of people, to have them listen, to have them participate, so that they don't find themselves in the wrong seat or needing you, right?
We're there no matter what.
All right. I think that is all we have for today. Thank you so much for being here. I know you're busy, and we appreciate your time.
No, thank you for having me.
And we will play this back for everyone to hear, so they can never say it wasn't available to them. All right, guys, this is Mindy again from All City with Jeremy Brewer. Thanks for joining us today. Have a great rest of your week.